Good morning. My name is Tia Smith, Tiasmith. I'm a policy attorney with ACLU of Nevada.
As far as Section 3 goes, let me be clear, the Nevada Court Reporting Board is not the transcription board.
I am testifying in opposition on behalf of the NOGC, Nevada Open Government Coalition, NPA, Nevada Press Association, and ONJ, Our Nevada Judges Incorporated.
Good morning and welcome to the Senate Committee on Commerce and Labor. And with that, we are going to move to our first agenda item, which is Senate Bill 191, revising provisions relating to court reporters and court reporting firms. And we will invite Senator Daly and any co-presenters he may have to the table.
Thank you, Madam Chair. Skip Daly for the record, representing Senate District 13. And Mr. Guild here is not really going to be co-presenting, but I did want to bring him up to introduce the people that are with the Court Reporters Board that are with us in Las Vegas in case you do have any questions. And Madam Chair, again, Skip Daly for the record. The others are there if they have questions. But I'll just go through the presentation. This is still in progress. The more I dig into this, the more I learn. And trying to get to some resolution. I don't think we're done yet. So with that, I will go forward, and there's really basically three parts to what we're trying to do with this bill today, and they came to me separately. As Mr. Guild referenced, I was putting in a court reporter bill. The majority leader also had one that the association wanted, and she said, hey, if you're doing one, just put this into yours. And I said, sure, that's how come we got this Section 16, which I think is the easiest part, which is what the Court Reporters Association wanted. In that translation, because I didn't get that portion, the numbers that the Court Reporters Association wanted to have as far as the fees in Section 16 didn't get communicated properly to LCB, not their fault. They used the numbers that they got. So Section 16, as in the amendment that we put in, are the correct numbers from my understanding. And that section, I think, is ready to go. And I haven't heard any issues over that yet, but before we get done here today, I'm going to tell everybody that comes up for or against, I'll just tell them now, anybody that comes up for or against the court reporters bill, when you get done here, go to my legislative assistant, give them your name and phone number and email address, and we will have follow-up meetings and get this reconciled by the end of the week one way or the other. I'll try to make as many people as happy as I can, but we're going to come out with a work product that meets what I'm trying to get done and address as many issues as we can. And we'll go forward from there. So the other part that I can address would be the Section 4 provision. That part will still have a little bit of work in progress. I know some of you may or may not know if Legislative Commission had a regulation earlier in the interim where the court reporters came forward with the process to say, hey, we want to request third party, or how do we address a third party request for a transcript? The way they wrote it in their regulation, they were saying that they had to send out a notice similar to this. Whoever the other parties were could object, and whoever the other parties were, if they objected, they had to go to court to say, no, don't do that. I said that's exactly backwards, right? Which is why this says the other way. If you're a third party person, you're requesting a transcript, court reporter still has to give notice to the other parties. If the other parties object, the person that requested in the first place would have to go to court in order to have that be released. Because when I hire a vendor, I hire a court reporter, I pay them for a service, they have a work product that they give to me. In my view, that belongs to the people who requested it and paid for it. It's a little weird on how the court reporting process works, but people can request those. The only exception to that was we're trying to get to the real point of why people even ask as third parties. Attorneys ask for expert witnesses for impeachment purposes and various things. What did they say in a previous case with similar situations, and are they contradicting themselves now? So in this proposal in Section 4, we're treating the expert witnesses differently and telling the Court Reporters Board if they end up releasing the expert witness testimony portion only, they have to redact the other non-expert witness portions of it out. We're going to work on that. I want to try to be able to capture the video recording that gets done on these things because technically, apparently they're not covered by the Court Reporters Board, so they wouldn't be covered by this provision even though I tried to add them in. So unless we get them actually covered by this statute or another one, right? I'm not planning on creating a new board. They wouldn't be bound by this anyway. But I think it's important. It needs to be captured. If attorneys hiring a video recording outfit instead of a court reporter, then there's nothing binding in the law right now from the video outfit reselling that to whoever they want to. And I think that's wrong, and we need to try to get that protection there. Which brings me to the next part of the bill, which is still up in the air. Trying to work on this and help the court reporters figure out how they can address what I view, and I've talked with people that do the video recording, I've talked with the court reporters, what is, in my view, what the sum of the video recording people are doing, which is unlicensed court reporting. Whether they're doing it by video or they're doing it by the machine that we're all used to, they're still doing recording of a proceeding, making notes, then they're transcribing their video into a document. The only thing they're not doing is certifying it because they're not court reporters, and only court reporters can certify. Otherwise, it's unlicensed activity. I know there's going to be a gentleman that comes up and opposes this later, and he's going to say, I asked him, I says, are you licensed? And he says, well, yeah, I'm a licensed notary. And I'm going, really? What's the education requirement to become a notary, and how long does that take? About 6 hours, and you take a small little test. There's nothing behind all of that. There's nothing in the law currently that says they have to be proficient at making video recordings, although they wouldn't be in business long if they weren't. Nothing in the law that allows them, there's a dispute over anything that allows them to give an oath to a person to swear them in. There's a dispute over the transcribing. Can they transcribe? What's that activity? And then everybody agrees that they can't certify whatever document that they produce on paper. So when I approached this, when I first talked to the court reporters, the original version of the bill basically was going to pull video recorders into the court reporting board and say, whether you're doing it through the stenographic machine or you're doing it through video, you had to be licensed as a court reporter, either direction. Then what they came and told me, the court reporters, they said everybody that's doing videography would have to, in their business, go to 2 years of school to become an actual court reporter, to take the test, to get the license as a court reporter, and nobody wanted to get that done. There is an issue over a shortage of court reporters that actually do it the traditional way. And then there is the issue that when you look at Section 2, which we don't have any changes to, one small fix if I can get to it for municipal courts, but I won't go into that right now. So in NRS 3, I believe it's for district courts, I might have it backwards, and NRS 4, I think is justice courts, there's already a provision in the law, that's why they're exempted from this, that says if they have been authorized by their county commission that they can have a person on their staff record proceedings in those courts that are not court reporters. So it's already heading towards the video audio being done by video and audio primarily. So we just have to get that going forward. So what this version of the amendment does, it takes out a bunch of the sections, basically says what are the actual processes that are necessary for you to be a court reporter. And I tried to strengthen those definitions. And basically it boils down to you're there in person, making notes, recording that, transcribing those notes into a document, and certifying that that document is accurately represents what transpired at the proceeding. We don't have that for the videographers where they have any type of education requirement in order to do this work. They don't have any continuing education requirement for doing this because they're not covered by the law. There's no discipline for them if they're doing that. And I do know that court reporters have told me, I said, well, just go after them. It's illegal to do what they're doing. And they said they had a deputy attorney general that said they couldn't do it for what it is. So we need to get that cleared up as well, which seems absurd to me. I think if you're an unlicensed lawyer, an unlicensed doctor, that board has the right to go after you for unlicensed activity. But if the court reporter board is being told by their deputy attorney general they can't do that, I'm saying, so if you're going to get licensed, you got to pay the fee, you got to prove that you had the education, you have to pass a test, you're subject to discipline. Or you can just say, no, I'm not going to get a license, you can't touch me, I'm not covered by your law. So I would want to know, I says, who are the fools that are getting licensed if you can do it unlicensed and no penalty? So we have to get that part fixed. Same reason we have any type of board and licensing is for the benefit of the public, so that the courts, the public, anybody in those proceedings, the attorneys on both sides have confidence that the documents and the record that's produced is an accurate representation. And we've done that through licensing. So now we have this split between the old style that we're all familiar with, court reporting with the machine, and the way the courts are going with video, audio recordings and various things, and how do we merge those two. So it's my intent, when we get everybody in my office, we're going to sit down and make them happy, is to not create a new board. So it'll be the court reporters board that has this. They can give out a certificate for court reporting and a certificate for video recording, and we may have to establish, and this language has kind of already been written, it was how the bill was drafted, SB190, I believe, last session with Senator Hammond's proposal. There's been some refinements done by the board. When I asked them to say, hey, if you don't like this, send me an amendment, and they did a lot of work, so it's probably 80% there. And then the board would say, if you want to put an application in for a court reporter, here's the education requirement, here's the test requirement, here's the continuing education requirement, et cetera, and this is what you can do. And if you want to put in an application for a legal video recorder, or whatever that term we're going to use is, here's the education requirement, here's your test requirement, here's the continuing education requirement, and whatever else that needs to be done there. And then they can get a certificate to do that, and hopefully be able to get those two things merged together so that we can recognize that the way these proceedings are recorded and notes are taken and transcribed, and creating a document that's presentable and acceptable by the courts and the lawyers, and the public can be confident that that's an accurate record of the proceeding, can only be done if we bring those two methods under a licensing provision with the rest of the safeguards that I just mentioned before. I can go through the rest of the bill. I think I talked about Section 4, which we're working on. Section 16 is basically done. And then the rest of the bill, whether the original version that would require people to have to go to school to get court reporting, this amended version, which the Court Reporters Board has approved and said they can live with that because it just makes that, the other activity illegal, and that you would have to have a court reporter in the room taking it the traditional way. You can have a video recorder there as well, and he doesn't really necessarily need to be licensed, because that video recorder cannot transcribe any video recording, and they can't certify the document. What I really think is the better way is going to be the third way, the harder way, not harder, but a little more words. Have the two certificates under the one board, you file the application, and we do that the normal way we do boards in licensing. One for court reporters traditional, one for legal video recorder, however we want to do that. We have to work out the part of, do you have to have both there at the same proceeding? That's the way the court reporters are thinking it should be. I don't know that that would necessarily be necessary. If we have the right training for the video recording people, then I think we can go both directions. Because I know the courts that are doing it now with their staff that are not court reporters are making those transcribing it, and that becomes the official record of the court, and they don't have to have both there. So I think that's it in a nutshell on what I've learned now about court reporting and where we're at in the process. And I just believe that anybody that says they're a videographer, unlicensed, but they're just as good and we do it better, et cetera, they're unlicensed. They have a notary, and that's it. There's no verification on their experience. There's no testing that they're actually capable of these things. There's no public confidence in the reason that we have boards for that unlicensed activity, in my opinion, which is why I believe it needs to be licensed. With that, I'm happy to answer any questions. I don't think I need to go through step by step on the bill on either one of them, because I think it's going to look differently, but I think conceptually you understand where I think we're headed.
Okay, and also for committee members, if you had a chance to look at the amendment online, it sounds like there might be more changes coming, but there was an amendment from Senator Daly online. All right, do we have any questions from the committee? Senator Ellison.
Thank you, Mr. Daly. I don't have a problem with the fee structure, but one of the questions I've got is, you look at rural areas, you can't get recorders down there 90% of the time, unless it's a severe criminal case. But I'll give an example. The courts now, they don't even take the people out of the jail. They have a video session that goes through to the judge, and the judge ORs them or bounds them over, or whatever they do. That's a common practice. And you're saying the videos are not legal? This building, for one, videos everything we do. So is that not legal? I'm just saying we've got to come to a common ground with where they got a video and not video, and I think that's really important.
Madam Chair, Skip Daly again for the record. Thank you, Senator Ellison, and I did go over that in subsection 2, those court proceedings. There's a process. It's enabled in the law. I'll say it again, make it clear, that there's a provision that says in NRS 3.380 that says if they're approved by the county commissioner, by the county commission, those courts can use a person who's not a court reporter to video and record those proceedings, and that becomes the record for that court. So all of the stuff you're saying about the jail by video and all that stuff is covered by that. It's not going to be affected by this. These video proceedings are not court proceedings, various things. So we're talking apples and watermelons. It's not the same, right? I'm not saying these recordings are illegal. I'm not saying a recording for a city council or a county commission meeting are illegal. We're talking about court proceedings. So let's make sure we're all on the same page. Court repeat proceedings and the ones that are in existence now where they're doing this recording under the statute that they have. So we're not talking about the same thing, just to be clear.
Thank you. I just want to make sure that we're talking apples for apples. There's no watermelons in here. All right, thank you.
Did we have any other questions? I do have a question. So with some of our court reporters nearing retirement age, worrying about the future of court reporting, especially I think maybe in the rurals, do you see this having any effect on that, on having enough court reporters for our court proceedings?
Thank you, Madam Chair. Again, Skip Daly for the record. And talking with one gentleman who said he only has the notary deal on that, I get some of what he said. Some of what he said was valid. There is a shortage of court reporters, regardless of people aging out or various things. There's less people coming in and out, et cetera. So I do recognize that. You have a hard time getting people to different places, which is why some attorneys are going to the video recording. I think eventually, if there'll be a shortage of them too, but we still have to get them licensed so that we know what their credentials are. We know the public can be reassured and the courts can be reassured that the person coming out actually has the ability and the training on how to document the proceeding, and instead of just saying party 1, party 2, party 3, they say the names and various things. So there's quite a few different steps of that. But yes, I think having the 2 paths is going to make things better because people will have the option. We have to work through a couple of minor things, and there may be disputes with one versus the other, but there's going to have to be a compromise, and that's what I intend to try to get to.
Thank you so much. I appreciate the fact that you're meeting with all of the stakeholders and trying to come to a compromise, because I think maybe the only concern is just that some of the court proceedings may be challenging if not as many people are entering the industry. And so while I completely understand licensing, I just want to make sure that we have enough people to be able to be at those proceedings to get the job done. Any other questions?
One other comment, if I can.
Please.
And I neglected, so my bad. Skip Daly again for the record. And yes, we want to try to make that part done, but I believe the people that are producing these records and doing this work need to be licensed, and that's the direction I want to try to get to. There is a provision that was added to this amendment that came from the court reporters, partly on my suggestion regarding the amount of fees that the court reporter board can charge for people that are applying and those types of things, where they're proposing to, instead of have that, locked in statute, to allow them to make those fees and adjust those fees by regulation. Some people like that, some people don't. I can tell you that there are several boards in other areas that already have the ability to make those changes in regulation. Not everybody. I know there's a bill where NDOW is proposing to do it by regulation. We copied that language from there. I think it's useful because it says not only could they potentially increase, but they also could decrease. And then there's a formula that they would use on how much they could increase or when they would increase based on, I think, a consumer price index or whatever. And that's in there. I forgot to mention that section. I would hope to keep that unless somebody in the committee or majority of the committee says, no, we don't like that. We won't do it.
Thank you so much. Not seeing any other questions. We'll have you go ahead and step back from the table. Thank you so much, Senator. And it looks like our court reporters in Las Vegas got lucky. They didn't have to answer any questions for us there. And we are going to move to testimony in support of Senate Bill 191. Please approach the tables in Carson City and Las Vegas if you'd like to testify in support.
Good morning, Madam Chair, Vice Chair Daly, committee members. My name is Peggy Elias, E-L-I-A-S. I was a Nevada Certified Court Reporting Board member for 12 years and am currently on their Legs and Regs Committee, and I will be doing the presentation for the Nevada Certified Court Reporters Board. And by way of background, the state of Nevada adopted the FRCP as the NRCP for uniformity of state and federal procedure, with the understanding that where state law differs or there is a conflict between state and federal law, the state law is to be followed in state court venued cases. State law in Nevada does differ from federal law by virtue of the fact that the state of Nevada regulates the practice of court reporting. Under NRS 656020, the legislative declaration, 1, it is hereby declared to be the policy of the legislature to encourage the proficiency in the practice of court reporting as a profession. B, promote efficiency in court and general reporting. And C, extend to the courts and public the protection afforded by a standardized profession by establishing a standard of competency for those engaged in it. Number 2, the practice of court reporting in the state of Nevada is declared to affect the public health, safety, and welfare, and is subject to regulation and control in the public interest. State law currently says depositions shall be taken before an officer authorized to administer oaths by the laws of the United States or of the place where the examination is held. Since federal law and state law differ, state law prevails in Nevada venued cases. The prevailing law in Nevada, depositions, court reporters take depositions and certify transcripts by virtue of the fact that the Nevada legislatures deemed that the court reporting profession be regulated by NRS 656 and NAC 656. Notaries are regulated by NRS 240 and the Secretary of State's office, not NRS and NAC 656. There has not, since 1995, been a subsequent law passed by the Nevada legislature giving videographer notaries the right to take a deposition. The 1995 legislature said, and its minutes reflect, that notaries can no longer take depositions. At the time it passed the law, the court reporters no longer have to be notaries. If the Secretary of State's office wanted taking a deposition listed under notarial acts, they could have gone before the Nevada legislature in any odd-numbered year since 1995 and added the language, but they have not done so. Also, it is not the administration of the oath that is a violation or unlicensed practice. It's typing up and certifying the original.
And there's actually a 2-minute limit for testimony and support. We've given you an additional minute, but if you want to go ahead and close up the comments and then provide anything in writing to our committee secretary, we'll make sure that it's on the record.
Okay, I will submit my outline to you all when I'm done. We do have 11 exhibits showing that there are violations, and our main purpose today is to, our District Attorney General said that we do not currently have language authorizing them to prosecute the unlicensed practices. So our main goal is to license the unlicensed practice. The board is not seeking to put any person or entity out of business with this bill or prohibit them in any way from doing their jobs of legal videography.
Thank you so much. We're going to go to the next person, but please do turn in that testimony because we want to make sure we have all of your testimony in writing in the record. And we thank you so much for being here today. Would anyone else at the table like to testify in support of Senate Bill 191?
Thank you. This is Kevin Diamond. I'm a member of the Nevada Certified Court Reporters Board and practicing attorney for 32 years. I know it's only a 2-minute window, but I do want to encourage the board to review the transcript of the hearing in front of Judge Williams that occurred. I'm more the I come with the practical side of how this actually works and how it doesn't work. And one of the biggest issues that we see as attorneys is the foundation that needs to be laid in order to use these transcripts in a court of law, and the judges that aren't allowing transcripts that aren't properly certified. When you have a certified court reporter that reported a deposition, for example, in their certificate, it says that they certify, they transcribed their stenographic notes via computer-aided transcription into written form, and that the typewritten transcription is a complete, true, accurate transcription of those notes. When a court recorder, when a videographer does the transcription without a certified court reporter, typically what the certification says is that the videographer transcribed or supervised transcription from recorded audio and visual record, and that it's a complete, true, and accurate transcription. The problem comes from NRS 240.063, where it says that notaries only know the contents of what type of document it is, but they're not deemed to be evidence that the notary knows the contents of what it was. What does that mean? That means that a certified court reporter who is there at a deposition, who's typing, they've taken the notes that they heard firsthand, that they typed, and then transcribed them, as opposed to a video being presented to some third-party transcriptionist who wasn't there.
Hi, sir. We're actually over 2 minutes, so if you want to finish up your comments and make sure that you submit them to the committee secretary so we have everything. Thank you.
Sure. Thank you, Madam Chair. The point is that without the proper foundation and certification, many judges are not allowing these transcripts to be utilized at trial. So the people who utilize videographers that are recording these oftentimes will get to these transcripts that you can't use. So people have paid for nothing. So that is one of the biggest problems that we see in practical terms. And I appreciate the committee's time.
Yes, my name is Kimberly Farkas, Farkas, and I am here Madam Chair and honorable members of the committee. As a representative of the Nevada Court Reporters Association, I am a certified court reporter and past president of the Nevada Court Reporters Association, and I'm here regarding SB191 Section 16, which proposes amendments to NRS 3.370 regarding a rate increase for official court reporters in the state of Nevada. The rates for the court reporters have not been raised since 2015, and the time before that was 2005. So we are on our 10-year cycle to come before the legislature for a rate increase request. Court reporters in Nevada are independent contractors. They are not employees. They bear the responsibility of their own training, licensing, equipment, software, compensation to support professionals. They pay for their own insurance, taxes, retirement, and required continuing education credits. The increase is essential for several reasons: to attract and retain the highest quality court reporters in the country to come to the state of Nevada, to ensure that Nevada remains competitive with the surrounding states, which have cost of living adjustment increases and similar legislative rate increases, and to compete with the private sector, ensuring the rates are commensurate and enticing for court reporters to travel to the rural courts for hearings and trials. I believe this addresses your concern about not being able to get court reporters to travel to the rural areas. As the rate fee structure stands, it's not fiscally smart for a court reporter to travel to the rural areas for those rates. With the rate increase, I believe this will entice them to travel more to the rural areas. In conclusion, capturing the spoken word and creating an accurate record by certified court reporters is a skill of the highest importance to our state's judicial system. We urge the committee to support SB 191 Section 16 to amend NRS 3.370 favorably. Thank you very much.
Thank you so much. We are going to close support on Senate Bill 191 and open testimony in opposition for Senate Bill 191. And we'll start with our physical locations. We're a little blurry. Oh, there we go, in Las Vegas. But we'll start in Carson City if anyone would like to come up and testify in opposition of Senate Bill 191. And then we'll move to Las Vegas and then the phones.
Good morning. My name is Tia Smith, TIA-SMITH. I'm a policy attorney with ACLU of Nevada. ACLU of Nevada is part of the Nevada Open Government Coalition, so we echo their concerns about transparency, but we are really grateful to Senator Daly for being willing to work towards a bill that we can all be happy with, and we look forward to working together. Thank you.
Good morning. Good morning. My name is Jason Sanderson, Sanderson, and I am the owner of one of the founders of eDepositions LLC, a litigation support company serving attorneys, law firms, and courts across Nevada. A core part of our business is recording depositions using legally recognized non-stenographic methods that are fully compliant with the Nevada Rules of Civil Procedure, specifically NRCP 28 and NRCP 30. The Nevada Court Reporting Board has no authority over us. Let me be absolutely clear. We are not court reporters. We do not provide court reporting services. We are not a court reporting firm. The Nevada Court Reporting Board governs stenography, court reporters, and voice writers. Nothing more. According to NRS 656.030, the practice of court reporting is explicitly defined as voice writing or any system of manual and mechanical shorthand writing. That is their jurisdiction. They are not the deposition board. They are not the testimony board. They are not the transcription board. Yet once again, this board is overreaching, attempting for the fourth time to legislate away its competition, not to protect the record, but to protect a dying monopoly. The court reporting industry is dying, and the numbers prove it. The court reporting industry is collapsing, and this committee needs to understand the catastrophic impact this will have on the legal system if alternatives like digital depositions are eliminated. This is not a criticism of court reporters. Their role is respected and valued, but the facts paint a very clear picture of what is happening. There are only 261 court reporters in Nevada. Only 171 actually reside in Nevada. More than half of those 171, 88 reporters, have been licensed for at least 25 years. That means
We are over 2 minutes, so I'm going to have you finish up your comments and then ensure that the committee secretary has them.
Perfect, thank you. Just real quick, yesterday I checked Nellis to see if there was any opposition to this bill. What I found was telling. The 4 largest court reporting firms in the country are against this legislation. Think about that. The very companies we compete against also believe this is a bad bill. If even the largest players in the court reporting industry, companies with a vested interest in deposition recording, are opposing this bill, then the message is clear.
Okay, thank you so much.
Mark Ivy, thank you, Chair, for allowing us to talk in opposition. I'm the CEO and founder of eDepositions LLC. To quickly just run through this bill under Section 4, the question of third-party transcripts and recording requests is a legal matter, not an administrative one. The issue should be determined by Nevada's judicial branch, not an unelected licensing board. The Nevada Supreme Court and the State Bar should be the ones providing guidance under the Nevada Rules of Civil Procedure, ensuring any regulation aligns with constitutional and legal standards. We would look to them to tell us how to handle those. As far as Section 3 goes, let me be clear, the Nevada Court Reporting Board is not the transcription board. Nowhere in this charter does it have the authority to regulate who can create a transcript from non-stenographic recordings. The rules of civil procedure are very clear on how that's handled. Even Judge Freeman ruled on this at the Second Judicial Court in 2018, saying the audio-video recording is the official record, and the transcript is just merely an aid to that record. What the Court Reporting Board is attempting to do with this section is to force their competition to outsource transcript creation to them, creating a monopoly on transcriptions from non-stenographic recordings. That's a clear violation of the Sherman Act, where the Supreme Court of the United States has ruled that a regulatory board made up of market participants cannot use licensing power to restrict competition. The worst part about this bill is 656.350 for criminal penalty. Under this proposed law, any violation of this chapter, whether by licensed or unlicensed individual or entity, would be classified as a misdemeanor. The board is attempting to grant itself prosecutorial power by adding that language. This means that if I or any other litigation support provider create a transcript from an official video record at the request of an attorney, a court, or any other entity, the Nevada Court Reporting Board will have the power to pursue criminal charges against me. This is a blatant conflict of interest and should be reason enough for this committee to reject the bill. The courts have already ruled on this through NRCP, and that's what guides all non-stenographic companies.
We are
like
over
ours.
2 minutes, so if you want to close out your testimony and ensure that we get it to our committee secretary.
We cannot afford to ignore the reality that this bill does not solve the problem, it makes it worse. I urge this committee to consider the long-term implications and reject legislation that undermines the ability of our courts to function efficiently and fairly. Thank you.
Actually, we do have a question from Senator Flores.
And then possibly with the question, it might give you an opportunity to continue with some of the remarks you had written. So I think it helps both sides. I was curious. I think I heard Senator Daly and some of the support testimony ultimately that their desire is to create a standard to make sure that we have a minimum requirement of licensing, of training, of education, et cetera, to ensure that. And the question is broadly to any one of you, can you please tell us what's the education now? What's the standard? What is the training that your folk are undergoing now?
Mark Ivy, for the record, to answer your question, the training is all of our deposition officers that record depositions are thoroughly trained under the Nevada Rules of Civil Procedure that govern how depositions are taken and who they're taken in front of. So we have a stringent training program on that. When we talk about the notaries of you just have to be a notary, the notary is just simply to meet the standard of NRCP 28 that defines that a deposition shall be recorded in front of somebody able to administer an oath. We all know that a notary has that power to administer an oath or affirmation. So that's why we're notaries. We do not have a stringent licensing structure like the court reporting board does. Our disagreement with this is we compete against court reporting firms. That's our competition. We don't feel it's fair for a court reporting board to determine what their competition has to do. So that's a big part of why we're in opposition. If Senator Daly or anyone else wants to create a board for videographers and things like that, we're fine with that. We just don't feel it is fair for our competition to determine what that is. Thank you.
Thank you, Chair Pazina, committee members, Misty Grimmer representing the Nevada Resort Association. I'd like to express my appreciation to Senator Daly for taking time to visit with me on both of the bills that are up this morning. Between these bills and Contractors Board issues, I think I'm getting pretty close to having a chair with my name on it in his office. And we haven't even started workers' compensation yet. That is unless he kicks me out after this morning. Anyhow, for SB191, after visiting with the senator, I think I understand the intent of the bill and will visit again with my members to confirm that they think the necessary protections of court proceedings still exist after these changes. Our initial concern is that proceedings that don't take place in an open public courtroom, such as depositions, can still be held confidential. As the senator said in his explanation, I believe it is his intention that those transcripts could only be turned over to a requesting party with the permission of the parties to the proceeding. Again, I'll consult again with our members, but I would expect we will be moving our position to neutral. And if not, I will let the senator know. Thank you.
Good morning to the chair and the committee. My name is Alexander Falconi, ALEXFALCONI. I am testifying in opposition on behalf of the NOGC, Nevada Open Government Coalition, NPA, Nevada Press Association, and ONJ, our Nevada Judges Incorporated. I appreciate that Mr. Daly has addressed some of our concerns. I'll just emphasize that we specifically oppose the procedure for third-party requests, which creates up to a 60-day delay. If transcripts are not sealed, they should be turned over forthwith. The default status of transcripts, like access to the courtroom, should be public because judicial discretion is mandatory, not only to seal, but also to redact. The JAVS automated recording system is of the greatest concern because its use is ubiquitous and the videos have been used by the media on several occasions to expose judicial misconduct. I have observed the impact JAVS videos have on judicial elections, and it can be suggested that several judges have lost their elections, at least in part because of a JAVS video. We have provided a proposed amendment to Mr. Daly consistent with our concerns. In conclusion, we do not oppose sealing and redaction categorically. We only urge that the default status is public, that access be presumed, contemporaneous, and prompt, and that sealing and redaction occur only following an exercise of judicial discretion. This is consistent with the First Amendment principles, which emphasize that the free press is the guardian of the public interest and the independent judiciary is the guardian of the free press. No further comment.
Thank you, Madam Chair. Again, Skip Daly for the record, representing Senate District 13. And as I said in Government Affairs the other day, my record is still intact. 4 against, never have any neutral. I would like to just go back over a couple of things, and I think people misunderstand, especially in this Section 4 over the release of the third-party requests. So if anything gets into court, where it's part of the public record and all of that, none of this is touched by that. You have court proceedings, you have depositions, other things, you have arbitrations, mediations, a lot of different things where you may have a proceeding where someone's going to want to request that if there was a mediation over a labor dispute and somebody wants to, request that press or whoever. That is not a public work document, and that's what this is trying to get to. So I think they misunderstand. I think we can come to some resolution on that. We're trying not to violate anybody's free speech, but as I said, if I hire a court reporter for a deposition or a mediation because I want to have that record, and I'm hiring that person to make that record, and I pay them for that record, that work process belongs to me. Court reporters may dispute on that, but that belongs to me. So a third-party request would have to get my permission to release it. And that's what we're trying to get to. Expert witnesses, we were trying to be conscious of attorneys that would want to get testimony of expert witnesses for impeachment purposes, various things. So I think we can work through that. I did want to come back, thank you for the question on that. And that national certification that Mr. Scalari talked about, first of all, is not required in Nevada. Nevada has no oversight over what is in it, what isn't in it. We don't know if there's continuing education. And, you know, we just don't have that control. And that's not the way we operate on the boards that we do. In regard to the testimony from Mr. Ivey, I believe it was, and Sanderson, that the courts should trouble this, and the Nevada rules of civil procedure should cover all of this stuff. I said, if that was the case, we wouldn't be able to even have a court reporter board because the court says over that. We can set jurisdiction or a statute and make rules and require these various things, and then they still have to comply with the rules that the court set out for procedures within the court as a separate issue. So that was, I think, a red herring thrown at the committee, which is a lot. So every single person here, I'll say again, north or south, if we have to set up a Zoom, we will. Get a hold of my office, give your name and your phone number and your email address to my legislative assistant, and we will get a meeting set up, and we'll go through some of these issues, and I will do my best to come forward addressing as many issues as possible. End goal, the video people need to be licensed. I'm not planning on making a new board. There may be two paths under the same board. And it's not about putting anybody out of business. It's about making sure that the state, the public, the courts, and the people, the witnesses, the people that have the least amount, or not witnesses, but the people that are participants that have the least amount of knowledge about all this stuff are protected, that when they hire a person, they're going to get the work product that they think they're going to get when they hire them. So that was it, unless you have another question for me.
Thank you so much, and I am sure everyone appreciates that you're willing to meet with all the stakeholders, and I look forward to hearing how that goes. All right, with that, thank you so much. We are going to close the hearing on Senate Bill 191, but stay seated because we're moving to Senate Bill 198, revising...